Brown vs. Board of Education was a case heard in Topeka, Kansas in 1951. 13 parents of 20 black elementary-age students in Topeka tried to enroll their children in white elementary schools in September of 1950. One of those parents was Oliver Brown, father of Linda Brown. Linda wanted to go to her neighborhood school. Instead, she had to ride the bus for over an hour to the black elementary school. The court named Brown's case first because it took place in Kansas and not in a southern state. This way, the court can demonstrate that segregation was not solely a southern issue. We are standing outside the courtroom of the U.S. Supreme Court in Washington, D.C. The court is hearing oral arguments today in the case of Brown versus Board of Education. Chief Judge Earl Warrell of the U.S. Supreme Court is ready to begin. There are 3 lawyers representing the students. The most famous one is Thurgood Marshall. Mr. Marshall, you are here today to challenge the ruling made by this court in 1896 in the case of Plessy v. Ferguson, is that correct? Yes, Your Honor. Please tell us, Mr. Marshall, why do you think we should throw out the idea of separate but equal? In 1896, one of the judges on the court, Judge Harlan, disagreed strongly with the idea of separate but equal. Judge Harlan said that our Constitution is colorblind and neither knows nor tolerates classes among citizens. I think Mr. Harlan's day has come. Please explain yourself, Mr. Marshall. Your Honor, the segregation of black and white children in public schools is a violation of the 14th Amendment to the United States Constitution. In 1868, this amendment forbids states from denying individual citizens due process and equal protection under the law. But that was 1868. What about today, 1953? Today, this country is very different. Black men and women have shown that with a proper education, they can become successful lawyers, doctors, businessmen, engineers, and scientists. What does that have to do with equality? Separate is inherently unequal. Even if the black schools and white schools have equal buildings, books, teachers, and salaries, separate schools offer unequal educational opportunities. Gentlemen, are you arguing for the schools? Yes, we are, Your Honor. I am Mr. Lindsay Almond, Jr., the Attorney General of Virginia. With me is Mr. Albert Young, the Attorney General of Delaware. You may begin. Your Honors, we would like to make clear that despite the manner in which the appellants would characterize our argument, we do not propose to take any position regarding the ethics or morality of segregation. Now, unlike our opponents, do we believe that it is appropriate for the courts to resolve this social issue. So what are you arguing then? We argue that the law, as stated by the 14th Amendment and as interpreted by this court for the last 50 years, permits segregation in public schools. Can you support this statement? We begin by disputing the claim of the appellants that the 14th Amendment prohibits racial segregation in public schools. The 14th Amendment does not guarantee anything more than equality with regards to the fundamental rights of life, liberty, and property. We are familiar with the 14th Amendment. The history surrounding the 14th Amendment's passage contains many clear statements that no one intended for it to prohibit racial segregation in schools. We also note that this interpretation of the 14th Amendment has been accepted by the court since Plessy v. Ferguson. It has been adhered to in numerous rulings throughout the state and federal court system. The court thanks counsel for both sides for their presentation today. The court will soon share our decisions on this matter. Ladies and gentlemen, we conclude unanimously that in the field of public education, the doctrine of separate but equal has no place. We also find that segregation violates both the 14th and the 5th Amendment's due process guarantees. We expect school districts across America to end segregation with on deliberate speed.